Hi, I'm Chuck Stull from Kalamazoo College. I'd like to introduce our second video on intellectual property law, and this is looking at the type of intellectual property law that protects inventions, new ideas, and that area of law is known as patent law. This is the second in a short series on intellectual property law, and this video will focus on patents. Patents are used for machines, for different processes, for new medicines. Patents protect inventions. And specifically, the patent protects the underlying ideas. Patents, in order to be protected, need to be a new idea, so they need to be novel. It needs to be non-obvious to a skilled practitioner in the field, right? So it really is something that is a new invention, and they need to be useful. Right? So sometimes these are called utility patents. Now, there may be some things like this patented dog cover that don't seem obviously useful to me, but they still would be eligible or could be eligible as something that did have some potential use. Now, patents, unlike copyrights, need to be registered. Right, so they need to be registered with the U.S. Patent and Trademark Office. This is part of the federal government, part of the Department of Commerce. The registration is not cheap or simple. The U.S. Patent Office examines the claim and then determines whether they should accept or reject the patent. And there typically is a expensive legal search before patents patents are applied for, just to try and figure out, is this something that is new and patentable? The patent protection is relatively short. In the United States, it is currently 20 years from the time of filing, so much shorter than copyright. Now, like copyright and other intellectual property, as well as physical property, patent rights can be transferred either by license, by sale, they can be given away, they can be bequested to heirs, and so forth. Now, it is difficult to know when payment is necessary, and even negotiating tends to be expensive if you know that you need a patent in order to operate a particular device. Right, so we don't have those kind of automatic licenses set up for patents in the most part, like we do in many cases for creative works and copyright. Now, patents can be either narrow or broad, and it depends on the claim made. And so someone could make a really wide claim, which would then give them broad protection. That would mean that people using a wide range of related ideas would have to pay them, would have to license to use that. But those are harder to get approved. Or you can make a narrower claim saying, I invented this small specific thing, and those are easier to get approved, but it may be also easier for competitors to find a way to work around that patent and make a competing product without infringing. Now, one really important idea here is that independent creation is not a defense. And so someone could have a novel idea, but if someone else had patented it, they wouldn't be able to use that idea even inside their own manufacturing, inside their own devices. So patent use is going to require approval of the patent holder, either through licensed use, by paying a fee, or we often have in certain companies who are sharing patents, what's known as cross-licensing agreements, where there may or may not be a fee involved. And any other use is an infringement. And infringement means that the patent owner can collect damages from the violator, and they can prevent that company or that individual from continuing to use the patent. There isn't the same kind of established range of fair use. There is really very, very limited fair use. So, for example, to demonstrate drug effectiveness of a substitute in FDA testing, that would be something where you would be able to use the other patented drug. So one of the major problems with patents is that the rights are not clearly defined and they're not easily knowable. And firms often unintentionally violate patents, and patent holders often may unintentionally or intentionally overstate their rights, right? Making claims of infringement when none exist. And sometimes a violation may be hidden inside a process, inside a factory, and people even looking at the product itself would not be able to tell if a patented process had been used. Another problem is that bad patents may be granted. The patent office, while they have a large number of examiners, are not perfect, and they have issued patents that on closer examination should not have been examined, and in court have been challenged and overturned, and the patent has been dismissed. There's also a problem with patent trolls. These are companies who don't use a patent to produce, but just use it to collect fees from companies who want to avoid lawsuits. And often those patents may be pretty weak. They may be ones that wouldn't really stand up to a full court challenge, but companies might pay kind of a nuisance fee to the troll in order to avoid the expense of going to prove that that patent that the troll company owns wasn't valid. Anyway, we will talk more about patents, both their cost and benefits, in class. Thanks for listening. This is Chuck Stahl.